We are all here. Fantastic. All right. Hello, everybody. Congratulations, finalists. Thank you, judges, for being here. So I've explained everything to the judges, how it is working with Team 2, so they understand. And with that being said, I will be your timekeeper first off. So you'll be looking to me for the time. Is there any questions, guys, before we get started?
Yeah, I would just say that the petitioner will be asking for 2 minutes in rebuttal. I don't know if you wanted to do that before as housekeeping or. Okay.
Yeah, thank you very much. Okay, let's get it started. Welcome to the 2021 Charles S. Desmond Moot Court Competition. My name is Canio Morosco. I'm the president of Buffalo Moot Court Board, and I'll be the timekeeper for this round. This year's competitors will be arguing the case of Cameron v. Ridge. On behalf of the Buffalo Moot Court Board, I would like to thank the judges for volunteering their time and for making this competition possible. Shortly, we will begin the round with arguments from the petitioner and conclude with arguments from the respondents. The petitioners are Team 1, Joshua Larman and Lucy Shepard, and the respondent is Team 2, Nicholas Ramirez. The judges for the final round are Dean Aviva Abramowski, Professor Anthony O'Rourke, and Professor Lucinda Finley. Judges are encouraged to offer comments and suggestions to the competitors at the conclusion of the round. However, scores will not be offered at this time. Judges should be aware that the team numbers are random. They do not reflect the rank in the competition. We will now begin the final round. Oyez, oyez. The United States Supreme Court is now in session. Presiding are the Honorable Justices, Chief Justice Finley, Justice O'Rourke, and Justice Abramowski, hearing the case of Cameron v. Ridge.
Welcome, and the counsel for the petitioner on the first issue, you may approach the podium and you may begin.
Madam Chief Justice, and may it please the court. My name is Joshua Larman, and I, together with my co-counsel Lucy Shepard, represent the petitioner in this matter. Today, we will urge this court to re-examine the doctrine of qualified immunity and restrict it to those immunities recognized at common law in 1871. And we will urge the court to take this action for 3 reasons. First, that the expansion of qualified immunity under policy auspices has created a doctrine that is unwieldy and unworkable. Second, that even with limiting qualified immunity to those immunities recognized at common law prior to 1871, the doctrine will still be available for several classes of officials qualified immunity was created to protect. And third, that this court's changes to both the summary judgment and federal pleading standards together afford defendants named in Section 1983 lawsuits more protections and thereby render qualified immunity less essential for the defense on those claims. But Your Honors, before I begin there, I would just like to say what the petitioner is not asking for. We are not asking here today for this court to repudiate the doctrine of qualified immunity. It is petitioner's position that there is still a place for qualified immunity in the legal system. However, we would just ask that when it comes to the application of the test for to whom the qualified immunity can apply to, that test being in Wyatt, the 2-part conjunctive test, that first a court must look to those immunities of common law and then look to policy considerations. A petitioner is asking.
Counsel, let me ask you a question on that. So you said you're not asking us to essentially repudiate qualified immunity, but return the doctrine to those immunities that were recognized in the common law. I'm well aware in the common law of certain absolute immunities that were well established, such as for legislators, judges, prosecutorial and investigative officials. But what qualified immunities were recognized at common law? And by that, I do not mean a good faith defense. That was a defense that say police officers could invoke, but an actual immunity from suit that was qualified and could somehow be overcome. What of those existed at common law? Because I want to clearly understand exactly what you're asking us to return the doctrine to.
Well, Your Honor, I would say that as far as those qualified immunity as a doctrine is a judicially created doctrine, recognized by this court, in the middle of the 20th century, but that it flows from the recognition of those immunities that you referenced, that judges ought to be immune when judging, legislators ought to be immune when legislating, and prosecutors when prosecuting. And so by what I mean is the classes of public officials to whom the immunities would apply would be those officials. And the other ones that you mentioned too, as far as investigative capacity as well, and different things of that nature, but it would be restricted to those commonly recognized immunities that the framers of Section 1983 would have been well aware of and had in mind when enacting the statute.
So those were absolute immunities, though. They weren't qualified, because you had said earlier in your argument that you were not asking us to basically get rid of qualified immunities. So aside from those absolute immunities that common law recognized, I still, want to know what qualified immunities did common law recognize?
Well, as you say, the defense, the good faith defense would be considered defense and not an immunity. So I would say that as far as in addition to those immunities, the legal record isn't quite clear that the emergence of the doctrine of qualified immunity would be really pulling from those. And so what we're asking for is essentially that's the policy considerations that the court has engaged in under Filarski and other be abandoned, and that we return to those common law roots of those immunities. As far as qualified immunity, the legal record, at least historically, isn't altogether clear about the framing that aspect of the qualified immunity, what could be overcome. But it is clear is that several categories of officials were recognized, and widely so, as having immunity from suit.
So can I just clarify, are you willing to keep absolute immunity for judges?
Yes, Your Honor, absolutely.
So is it absolute immunity for prosecutors?
It would be essentially for those that I mentioned, those categories of officials, those that were commonly understood to, as a followed through from sovereign immunity, the idea that the king could not be sued, and then carried on through the 19th century in the American jurisprudence, that those widely recognized as being immune when they're discharging their duties in a way that's not.
So it's absolute immunity. You're arguing for absolute immunity for legislators
when engaged in legislation.
Yeah.
Yes.
And what sort of immunity, if any, are you arguing for police officers?
Your Honor, that would be an example of the sort of quasi-qualified immunity, in the sense that they are part of they are discharging their duties under the executive branch by enforcing the laws, with the legislator making the laws and the judges deciding when laws have been broken or not, and what punishments to dole out for that. So in that sense, they would fall under that kind of sovereign executive immunity. And as Judge Finley or Justice Finley mentioned, that the good faith, although I understand that that is not an immunity, that the good faith defense commonly recognized a common law. For example, when a police officer believes in good faith that he has probable cause to search a car and then ends up not finding contraband, or makes an arrest on probable cause, or does a Terry search, the examples go on and on of how a good faith exception, or rather a good faith defense, could be asserted by police officers named in 1983 lawsuits.
So it sounds like you're essentially asking us to overrule a good 50 years of our precedents, starting with Harlow and Anderson versus Creighton, and all of the other qualified immunity cases, up including ones we decided last week or 2 weeks ago. We have this very strong principle of stare decisis. Why should we depart from stare decisis here?
Your Honor, that brings me to my next point regarding what the court ought to consider when departing from stare decisis, because this court has long recognized that on occasion, when circumstances demand, stare decisis must give way. And examples of that include Brown versus Board of Education, which of course repudiated the doctrine of separate but equal, Lawrence versus Texas, which overruled this court's holding in the previous case dealing with that, Bowers versus Hardwick. And so there is precedent and examples of this court doing just that. And in 1992, this court articulated 3 reasons in Planned Parenthood versus Casey that the court ought to consider when engaging in this kind of consideration, because it is weighty and petitioner is aware of that. Those being, first, whether the holding has proved to be unworkable, that it defies practical workability. Two, whether a reliance on the holding has emerged.
So I'm having a little bit of trouble with your argument now. So I can understand sort of the argument that Professor Bode makes in his scholarship, and that I take Justice Thomas to have made in concurrences, that
an added cost of. I'm sorry, Justice, you cut out a bit just there. I don't know if the internet connection was unstable, but I can hear you now.
I'm sorry, and I may have cut you off because I thought that there was some silence. So apologies if I either missed what you said or cut you off. I'm having a little bit of trouble understanding your argument. I can understand the argument that Professor Bode makes in his scholarship and that Justice Thomas makes, which I take to be that there was no putative common law immunity, that is sort of a misunderstanding of what the common law as it existed at the time that that Section 1983 was enacted, and we should step away from this and just abolish qualified immunity altogether. But if the argument is just that we just overturn Harlow, overturn the policy considerations and freeze common law or qualified immunity in the common law, well, the common law develops, right? We didn't have police agencies when the Ku Klux Klan Act was passed that resemble contemporary urban police agencies. So presumably a fair reading of this would just would take that off the table. You'd have to just look at the institutions that existed frozen in time. And we've cautioned not to do that for the Second Amendment, for example, and said that the Second Amendment doesn't just allow muskets. Why would we do this here? Why would we want to freeze the common law in a specific point in time?
Well, Your Honor, just flowing from the Casey factors, I would say that the current doctrine as it is has become unworkable in the Fifth Circuit split between Perniciaro and Sanchez, as well as the 10th Circuit split in Jensen versus Tanner. And so I understand the concern that by returning to those common law roots, that there could be this issue of freezing, of not being able to move with the times. But we've seen the opposite outcome result from the consideration of policy, where what Justice Kennedy warned us about, freewheeling policy considerations, producing a legal landscape that is unreliable, such that the second Casey factor, whether a reliance has emerged upon the doctrine, it's petitioner's position that one cannot rely upon something that is itself unreliable. And certainly I would just speak to the specific split in Jensen versus Tanner. The 13th Circuit relied on Jensen to grant the defendant's motion for summary judgment over the district court's ruling. And so to think that on the same day in the same circuit, applying the same doctrine to factually analogous cases, two panels came out on opposite sides of that issue. The doctrine it clearly is flawed, and the policy considerations, reasonable judges may differ as to what they consider a compelling policy reason when applying the test as it exists now.
So you mentioned policy. That is usually something more appropriate for Congress to consider. So why shouldn't we, the court, just say, look, let's let Congress be the proper body to decide whether they want to continue with expansive qualified immunities and protecting police officers so they're not unduly deterred from vigorous performance of their job by threat of lawsuits. I mean, to the extent that this really is a policy decision, why isn't Congress the appropriate body to decide whether to change the qualified immunity doctrine?
Your Honor, the question of institutional competence is certainly something that should be considered by the court. However, I would emphasize that given that this doctrine is judicially created, given that within the judicial branch, it has created these circuit splits, notably in the 5th and 10th circuits, as I said, that petitioners, or rather plaintiffs bringing these claims, must contend, and defendants must contend in defending those claims, that this is a problem that the judicial branch is well disposed to solve, given that it did create the doctrine to begin with.
Can I just asked for clarification. So you're arguing that you want to move it to common law and policy, not common law or policy. Is that correct?
Your Honor, the test
That's
as
common law alone.
no, Your Honor. The what petitioner is advocating for. I'm just trying to be aware of my time as well. I think we're still good. That the conjunctive test. It is a conjunctive test under Wyatt, and that has been affirmed in Richardson and then in Pilarski as well. And so, because of that, it is a conjunctive test, and so we would.
Could you give me an example of how the conjunctive test would lead to a different result than the disjunctive?
Your Honor, under a conjunctive application like the kind in Pilarski, you would first go to common law and then to policy. If there was a set of facts where you had a policy reason, but there was no root in the common law to support extending qualified immunity to a class of officials, then in that case, it would produce a very different. The conjunctive disjunctive dichotomy produces a completely different result, and it is our position that it is conjunctive.
You want it, so that would create a higher standard. Is that what I'm understanding? You'd have to do common law and also a public policy person in order to have immunity.
That is the current status of the.
So there could be immunities in the common law that would no longer be available under the standard.
Immunities. I'm sorry, could you ask the question?
Would there be immunities under the common law that would no longer be available once public policy is applied?
There would be potentially, Your Honor, potentially if there was found to be, again, this varies and must necessarily vary on a case-by-case basis under the current state of the law and the policy considerations that reasonable judges may differ in applying them to the facts of cases like the one at bar today.
Counsel, oh, sorry, I'll let you go. You see your time is up.
Sure. If I may conclude briefly, Your Honors, given the changes that have occurred in the sense that under the 3 Casey factors articulated by this court in 1992, petitioner requests that this court return the doctrine of qualified immunity and take out those and policy considerations part of the test articulated in Wyatt and affirmed by this court in Richardson and Filarski, and return the doctrine of qualified immunity to a more predictable, more sound basis rooted in the common law. Thank you.
Thank you. Ms. Shepherd, you may approach the bench and proceed to your argument.
Thank you, Your Honor. Madam Chief Justice, and may it please the court, my name is Lucy Shepherd, and I'm arguing the second issue of our petition for petitioner Serena Cameron.
And actually, I want to start right in there because
Sure.
the question I was going to ask Mr. Larman when time ran out, it really relates to how what he's arguing relates to the issue that you're arguing. I understood Mr. Larman initially to say he wants all of qualified immunity doctrine, whether it's pertaining to government employees or private actors, to return to just the immunities existing at common law. But then he said it could be a disjunctive test, common law and policy. So I want to ask you that question. What is petitioner's position here? Should it be just common law and that's it? Or should it be common law and policy?
Thank you, Your Honor. So I would say, based on Mr. Larman's issue and our overall opinion or our argument, that this conjunctive test, the conjunctive test was originally created by this court in Wyatt. There, specifically in the language, Wyatt created 2 prongs that were separated by
Right. I'm quite familiar with Wyatt. But I want you to answer my question. What is petitioner's argument here when you put the 2 issues together? Is it that the only immunities that should be recognized in Section 1983 cases are those that existed at common law and none of this policy stuff? Or is it first you consider the common law and then you can also consider policy? Because I heard Mr. Larman arguing sort of both of those at different times, and they seem to me like contradictory positions. So this is your
Right.
chance to say, what is petitioner's position on this question?
Right. No, and I understand, and I apologize if we were wavering in our argument. Our position is that the immunities at common law must be recognized. And right now, circuit courts are freewheeling with the policy consideration. So really our answer is that we must look to the common law disjunctively. We need to focus on that and do away with the heavy focus on the policy. But what I'm arguing is, given the current state of the law with this conjunctive test, where both prongs with history at the common law and policy are considered, if the court keeps this conjunctive test, the respondent here cannot assert qualified immunity. So it's a little confusing between the issues, but overall we're arguing that the test should be more disjunctive. Right now it's too focused on policy, but if we keep this conjunctive test, respondent cannot assert qualified immunity here.
Okay. So you said it's too focused on policy. So admittedly, yes. I mean, our qualified immunity doctrine for anybody, government employees in particular, since Harlow has become heavily focused on policy and virtually no mention of the common law anymore, except in cases involving private parties. So now my question to you is, if you're talking about we need to sort of have more rational consistency in qualified immunity law, if policy controls the immunity decision for government employees, why shouldn't policy also control the immunity decision for private parties who are working closely with government employees to deliver a service to government?
So we fear focusing too much on policy because this creates an unreliable doctrine. As Mr. Larman pointed out, policy is a subjective determination almost. One judge may think that one policy applies while another might, whereas in the common law, we have more of a consistency. We can ground the doctrine in common law because it's more of a foundation, whereas policy can go one way or another too easily, and parties can't rely on this nilly-willy, unreliable doctrine if it focuses too much on policy. But I do acknowledge that there are policy considerations at play. But again, we want to ground the doctrine in the common law. But if the court is worried about policy with medical professionals, I can address that. So with the two-part conjunctive test that's currently the law of the land that was created by Wyatt in 1992, this second policy prong, stated first by Wyatt and then more codified in Richardson and Filarski, there's three primary policy reasons that it asks courts to consider whether qualified immunity should be extended to these private individuals. And the first policy reason is preventing unwarranted timidity. And unwarranted timidity is really this tendency for private individuals to act too cautiously, to act too timidly, and really underperform. But I want to point, again, I'm arguing based on the current state of the law because that's what we have to work with unless the court decides to create a new test. But with this first policy concern, we don't really have that satisfied here. In Richardson stated when we have a private firm, there really is no concern for unwarranted timidity because there are marketplace pressures that exist. And these market pressures are really based on competition, and we want competition. We want the public contracting with private employers, the private sector, to obtain adequate services. And here, there wasn't adequate services provided. The facts of this case are horrendous. Petitioner, based on the lack of care that she received, her child died. She almost lost her life. And if we extend qualified immunity to private individuals here, like the respondent, we're almost ensuring that that will occur again. We're shielding bad actors. And I don't think that is really the purpose of qualified immunity.
We're not shielding the bad actors here. If you had simply sued them in state court for basic medical malpractice, why didn't you do that? Why are you trying to, turn it into this big federal constitutional case when the deliberate indifference standard is so much harder to meet than the, failure to meet the professional standard of care? And if you'd just gone and done that, we wouldn't even be, you wouldn't have even faced this qualified immunity problem. So if you're concerned about substandard medical care being provided to, people in the carceral facilities, and they're increasingly contracting out with private actors, it would seem that good old malpractice law is there to protect against substandard medical care. What do we need turning it into a big constitutional case for?
I acknowledge that, or we acknowledge that, and we do recognize that there is that opportunity to sue in state court for malpractice. But here we're talking about something much more than malpractice. We're talking about the Eighth Amendment. We're talking about petitioner's Eighth Amendment being violated based on cruel and unusual punishment. She was in a holding cell, again, based on the lack of care she received. Her child died and she almost lost her life. So I think this is much more than malpractice. This is her being at the hands of government and receiving a huge disservice that resulted in the loss of life. I think that's much more than malpractice. But again, we want to encourage private doctors and healthcare professionals to provide services to the public, and we need to attract these good actors, these good players. So again, with this conjunctive test, the most important policy reason, if this court decides to look at policy even, is preventing against this unwarranted timidity factor. When we have the private sector, the private firms at play, there really isn't a huge concern for unwarranted timidity. We also have potential.
So, Ms. Shepard, I'm a little concerned that when you have the private market in play, unwarranted timidity becomes an even stronger consideration, because I mean, a prison guard or a correctional officer is indemnified. Presumably Nurse Ratched might be as well. But in this case, and correct me if I'm wrong, there probably isn't that sort of indemnification. I'm not necessarily sure, per Justice Finley's comments, that even malpractice insurance would cover these specific claims. It seems like you're putting doctors in a position that they're not in the open market, which is taking care of extremely vulnerable people who are in carceral situations that don't have access to their own mechanisms of self-care, where there is an increased risk of death and harm that they simply wouldn't encounter if they weren't contracting with the government. And if that's the sort of situation, then wouldn't the special context of being in a contractual relationship with the government strengthen the unwarranted timidity concern?
So if I understand your question correctly, so basically, private and public, they're contracting, and yes, the private sector is aware of this vulnerable population that they will be serving. They're aware of it and they take that on, they take that risk on. And there's also several tools they have to mitigate that risk that still makes it attractive for that private company to contract with the public. They have insurance. They also, their risk is more diversified. So here we have Amherst Medical Group that employed respondent. They have an entire private practice. This isn't their sole service, their sole gig that they have. They're
Let
diversified.
me just ask you a question. What if they didn't have insurance? Or what if their insurance didn't cover these types of acts, intentional acts, or or malicious acts? If their insurance was deemed not to cover, are they now immune? Is there greater emphasis for their immunity to be available? Is that the determination of the coverage of the scope of their policy?
I just point out insurance as one tool. So I would say if they didn't have insurance, that doesn't mean they should get qualified immunity. I think insurance is just one tool that mitigates the risk of unwarranted timidity. So I think private firms have other tools. Like I said, they're able to provide more incentives to their employees. They're not in this strict government regimented system subject to rules and regulations. They have more flexibility than the government
Which
sphere.
is my other question. I mean, reading some of these cases, it appears to be that the court is looking at this issue of control, whether or not the private agent had the ability to make the actions, or whether or not, and whether they could control the government actors. Is that is that an issue for you, this distinction between control of who has the autonomy to make these decisions? And if so, how would that apply under these facts?
So I would say, and I do recognize in the case law, it does talk about control, and it also talks about oversight. So I think when there's no oversight by the government, there's really no reason to extend qualified immunity here. So specifically, I'm talking about the Richardson court case. And so in that case, in the holding, the court specifically said that employees of a private firm that is systematically organized to assume a major lengthy administrative task for profit in competition with other firms and with limited government supervision, that's the oversight that I'm talking about. If that is the scenario, then qualified immunity should not be extended. And that's the exact scenario we have here. We have AMG that's systematically organized. They employ 75 physicians. They also employ billing staff. They employ executives, physicians, assistants, administrators, and they're taking on this major lengthy administrative task of developing all policies for providing medical care at the holding center. They're also supervising, and they have no direct oversight by the county at all.
We're out of time because I had a question on Richardson.
I'm sorry about that. I would ask if I can
I'm happy to allow Justice Abramowski to ask the question, give you another minute or two.
Thank you. Do you see in Richardson that there's any distinction? That's a private prison with security guards, where the control of the corporation is pretty total, both to the employees and to the facility, and as distinct from a doctor in a mid-sized practice. Does the nature of the private enterprise matter, and the level of control available of the corporate entity of their employees?
I do acknowledge that prison guards are different than doctors. Obviously, they provide different services, but I do want to point out to that holding, the court said that it was looking at the facts, but that it was broadly applying that to other factual scenarios. So I would say, given that they made that strong of a holding about this private firm, systematically organized, et cetera, that I think the court should feel comfortable in applying that to the facts of this case, where, again, we have a private individual working for a private firm that is systematically organized. But I would like, and I would ask the court if I could please sum up.
No, I think in the interest of time, we're going to move on to respondents counsel. Okay.
Thank you.
And in fact, I gave you the extra time for the question. Okay. Thank you, Ms. Shepherd, very much. All right, Mr. Ramirez, respondent, and we do understand you're going to focus first just on the first issue, and when time's up on that, on the second issue. So we will try to keep our questions confined to the respective issues during the right block of time. So you may proceed.
Thank you, Madam Chief Justice, and may it please the court. I would also like to extend apologies and well wishes from my co-counsel. She did have a personal matter, unfortunately was not able to be here, but she wanted everyone to know that she extends her best. So as you said, I am focusing on the first issue, which is that qualified immunity, as the court determined unanimously, should respond to policy concerns, and that those policy concerns can warrant contracting it, or they can warrant expanding it beyond what was in place in 1871. And there are two very important reasons that we should continue that trend. First, qualified immunity is intended to serve a public interest, and that interest includes constitutional mandates that this court has handed down to the states that they now have to take on additional responsibilities, fulfill additional duties, and bring on additional people to fulfill. Secondly, if we limit the scope of qualified immunity to only what was recognized in 1871, what we're doing is protecting the people that Section 1983 was passed to expose to liability, but not protecting anyone that wouldn't have been envisioned by Congress at the time as being susceptible to that liability.
Well, but again, if we get rid of qualified immunity and just return it to the common law immunities, and Congress thinks there are additional classes of people that should be immunized, that seems like something Congress should do.
I can certainly understand that, and I do recognize that policy concerns are typically the realm of Congress. But when Congress remained silent on qualified immunity when it wrote Section 1983 and has since updated the statute twice, it recognized that the court had incorporated qualified immunity and was making those policy considerations on a case-by-case basis. And that's important because Congress can't predict necessarily where all these policy concerns are going to come from, because sometimes they come from the court handing down a decision that expands the constitutional exposure. Let me give you an example. We already know Estelle v. Gamble. That's the case where this court determined in 1976 that prisoners in jails, prisons, state facilities, they have a constitutional requirement of adequate health care. That wouldn't have been known in 1871. That's also why we now have to have medical professionals have access to prisoners. In the same token, the court recognized in 1972 in Cruz v. Beto that prisoners have to have access to religious practices
Okay,
and spiritual beliefs.
Okay, I think you're making a very good point, but let's talk about constitutional rights that were recognized in 1871. I mean, so here's the concern with the way qualified immunity has been expanded. We're now at the point where unless there is basically a case that is not just legally on point interpreting the constitutional provision at issue, but factually, virtually identical. So if you take what our qualified immunity doctrine is today, and you apply it back in 1871, here's what would happen. You have some local election official who just doesn't like the fact that there's this amendment that gives these recently freed slaves the right to vote. And, they come up to him in a polling place and say, I'm sorry, unless you can pass this literacy test, you can't vote. And they only give the literacy test to the Black voters, not to the white voters. And there is yet no clearly established factually identical case on point under our current qualified immunity law that for such a flagrant constitutional violation that Congress that we had just recently amended the Constitution to deal with, there would be absolutely no remedy. So haven't we strayed far from the intent of Congress that passed 1983 and said that it was supposed to be a very broad remedial statute for constitutional violations?
I can certainly understand that perspective, Your Honor, and there may be places that the court wants to revisit what they've established as far as the ways that you can defeat qualified immunity. And that's what the policy concerns allow us to do as well. The court isn't simply bound to say we're going to extend the doctrine, we're going to increase how it protects you. The court can also recognize that perhaps it needs to restrict the doctrine in certain places. So what I'm saying here is that the court has the ability to respond because of this analysis, which recognizes that even though something may have been recognized in 1871, it may not be functional at this point. And the court can take that into account and determine that we need to rein it in, or in this case, in the case of a doctor providing medical care to people within a state-run facility, extend it to protect them when they wouldn't have been considered in 1871.
So, Mr. Ramirez, we said in Tower v. Glover that we do not have license to establish immunities from a Section 1983 action in the interest of what we judge to be sound policy, right? We have to look to common law and to make a determination as to whether an immunity was so well established when Section 1983 was enacted that we presume that that Congress would have explicitly abolished them otherwise in the statute. Are you urging us to step away and overturn that determination and say that even if an immunity isn't well established in the common law, you can still get it? That we should just ignore the common law?
Not at all, Your Honor. The common law is important. It's something that should definitely be considered. And there's certain cases where the common law is so well established and rationalized in why it was established that the court can look at that and say, this is enough. There's a reason that this immunity is here. What I'm saying is that there may be extreme scenarios that would not have been envisioned that can warrant these policy considerations extending it. And in this case, the considerations would be the court expanding its understanding of constitutional rights that should always have been there for these people. These people should have been protected in 1871, and Section 1983 was passed partially to give that protection because they weren't receiving it from the state. The court has now made it clear, though, that the states do have to have medical care available. And for the state to meet that requirement, they have to bring in professionals that wouldn't have had a common law immunity established in 1871. I'm sorry,
So
Chief
you're-
Justice.
I think I just want to clear, I think I just heard you concede that, and this may relate more to the second issue, that doctors and probably nurses as well had no immunity from suit under the common law.
There was not a recognized common law immunity from suit for doctors in 1871 in general tort liability. However, you could also draw the comparison that at the time there were jails and prisons that would just rely on the jailers or prison members to provide some emergency medical care. And you could
But
perhaps look at that to say that they're serving a similar purpose.
But they didn't have immunity, a common law immunity from suit either. If you were a jailer or a prison warden and you were providing medical care, there was no common law immunity there, was there?
Well, law enforcement did receive a qualified immunity, and they would be considered law enforcement. And I think this actually goes to Justice O'Rourke's earlier
Whoa.
point as well.
So when somebody's providing medical care, they're law enforcement?
In this context, yes.
What case holds that?
Well, in this case, they're serving as security in a way. And in fact, most prisons have actually started training their hired nurses and doctors to also fulfill that responsibility. So in that case, they have medical training and they offer that medical care while also serving a security function within the prison and fulfilling the functions of the prison. Or the
What
jail.
was the immunity at common law for law enforcement or security officials?
So it was similar to the immunity that was mentioned earlier, where we recognized that law enforcement, government officials, they had to have a certain protection to make decisions. That's what was later incorporated by the court into Section 1983.
I'm
to give
aware
protection
that they
to
had a defense of good faith, but a defense is very different from an immunity. An immunity is you
apologize.
can't be sued. A defense is you can be sued, but you can assert in your defense that you are acting reasonably in good faith based on probable cause, didn't violate the Constitution. So what immunity did you said, prison guards, wardens, doctors in prisons when they were providing a dual function of security and medical care had some common law immunity. I want to know what the immunity was at common law.
I apologize, Your Honor. I misspoke, and it's because that's where we are now at with qualified immunity. It was drawn from the good faith defenses that were mentioned and recognized, and now it's become an immunity from lawsuit itself. And that's what
Right.
I was referring
We
to.
turned
So-
it from a defense into an immunity that is qualified because there is some increasingly limited ability for a plaintiff to overcome the immunity.
Yes, Your Honor. I misspoke, and I should have clarified. I apologize for that.
And I'm not, and if I understand the history of Section 1983, as Justice Thomas articulates it and as Professor Bode has articulated it, it's not even certain to me that there was any good faith, even defense, well-established good faith defense in suits about constitutional violations about constitutional violations specifically when Section 1983 was enacted. We might have just been wrong, right? We might have gotten that wrong in our prior opinions because we didn't look at the record as searchingly as Justice Thomas has and as Professor Bode later did. What evidence is there? Just looking at, if we're going to overturn and look to the history, what evidence is there that there were these good faith defenses for constitutional violations?
Well, Your Honor, I recognize that there has been an additional look with Professor Bode, Professor Thomas, and I believe Professor Scalia has even mentioned before his passing that there may have been a mistake in adopting qualified immunity in the first place, but that these certain expansions were meant to kind of address the mistake in a way. And I mean, the court is, of course, able to revisit the qualified immunity doctrine completely. That is not the question that's been presented today, and unfortunately, I'm not prepared to speak as to the idea of overturning qualified immunity as a complete mistake. I'm simply stating that.
I thought that was the question presented. Should we basically jettison all of this policy, clearly established law stuff, and just go back to, saying we presume that Congress meant to incorporate immunities that were well recognized and established in the law at the time they passed the statute, and that's it. And if Congress wants to write other immunities into the statute, they can. I thought that was exactly the issue we were talking about.
Well, we are talking about returning to at least a conjunctive analysis where it has to be rooted in common law to determine if the immunity would apply. And that would take us back to the good faith defense that you mentioned earlier. Our position is simply that the policy concerns have been accounted for the court, and they were accounted for the court when they first created that defense and when they first adopted any of these immunities in 1871, and that they've continued to be responsive because of a need to do that so that the public's interests are met. And in this case, that public interest is making sure that the prisons are able to bring in medical professionals to care for people because of the constitutional mandates. If we return to 1871, based purely on Congress not acting to say that it should expand, it's kind of a strange line because Congress could have also written into the statute when they've changed it twice since that you can't expand it or that they are limited to this specific period of time. Congress hasn't done that, and that's because Congress recognizes the court is certainly capable of taking into account these policy concerns.
Actually, it's my understanding, and correct me if I'm wrong, that one of these subsequent amendments that Congress made was specifically to put into the statute that, yes, judicial officers were immune.
Yes, they did limit.
So if Congress in one of these subsequent changes, in fact, wrote a specific immunity into the statute, but no other specific immunity was written into the statute, why shouldn't we interpret that as a pretty strong signal of congressional intent that that's the immunity they wanted recognized?
Oh, I would say that we could look to what Congress has been doing right now. Congress has been discussing possibly passing laws to remove qualified immunity. If Congress understood qualified immunity to already be removed as to these previous amendments, they wouldn't need to have this discussion now. And the court has ruled on qualified immunity and granted qualified immunity consistently since those changes, with no word from Congress that that was not their intention.
Perhaps Congress feels we've overreached and is seeking to rein in the court. But my question is there no case in which public policy, or when does public policy hit historic identifications in the common law? And as my co-jurors mentioned before, if the common law is constantly changing and moving, where do we look upon the spectrum of history to determine our point in time by which to judge?
I'm sorry, Your Honor, I see my time is up. Chief Justice, may I respond to Justice Abramoff?
Yes, of course, you may answer the question.
Thank you. We would look to just the historical precedent that we have, going through the cases going back to 1871. We would look through all of that to determine if there's a historical basis for an immunity that's granted. And if there's not a historical basis, unless there's a compelling policy concern, we wouldn't say that you need to extend it. As far as a fixed point in time, having a fixed point in time only really works if you don't have any other expansions, such as greater understandings of what constitutional rights should have been afforded, or expansions to government responsibilities. If we try to fix it right now, for example, and then next year governments have to hire surgeons, states have to have surgeons constantly in their jails, it's a bit different situation, and we have to reconsider it. I am prepared to argue the second point, Your Honors. If you may indulge me for just a moment while I take a brief drink of water.
Yes, yes, of course. And you'll get a whole new set of time for the second issue. Just let us
Thank
know
you.
when you're ready.
Thank you, appreciate it. All right, Your Honors, if you're ready, I am prepared to proceed.
All right.
And
Go
this
ahead,
is
and timekeeper, you can start the new clock.
now, as the second question, whether a private healthcare professional who is contracted to provide medical advice to a correctional facility can assert qualified immunity, I feel the answer is pretty straightforward, yes. We need to attract doctors who have special skills, additional training beyond what we would expect of the average person to fill these roles. We need to encourage them to make decisions based on that training and not delay or wonder. They need to be able to triage. And that takes just relying on instinct, which is consistent with their medical training and recognition of medical malpractice standards.
So, Mr. Ramirez, I'm sure we will get into these policy questions, but based on sort of my understanding of what your argument was in the first part, if we determine that the relevant test is conjunctive, right, that you have to first find in a common law immunity, and then we can look to the policy considerations to figure out how to elaborate on it, do you lose?
I admit that it is much more of a challenge for me, Your Honor. However, as I mentioned, the jails and prisons, they did not include doctors at those times. We do know that, at least through anecdotal evidence, there were occasions where a guard may provide some medical care. I would say we could look to that if the guard would have been held liable, if he would have had a good faith defense. Likely we would expect he would if he accidentally injured someone while he's trying to provide emergency medical assistance to someone in their jails. We should extend the same kind of protection to someone who's trying to make sure the health and safety of people within the state's care is maintained.
So is there any decision of this court, the US Supreme Court, involving the issue of whether a private actor who's providing contractual services to the government, or as in Wyatt acting under color of state law by invoking governmental process, should get qualified immunity when someone performing that type of function would not have been immunized at common law?
At common law outside of working for the state, no. We don't.
Yeah.
We didn't.
So you will concede in every single decision of this court involving private actors, that are acting under color of state law. We have started with the common law, said whether they were the function they were doing was or was not immunized at common law, and then used policy as a sort of support or bolster for the common law immunity. So I just want to be clear, you are now asking us to basically change the way we look at private party acting under color of state law immunity cases, and say, even if the common law would not have immunized this type of actor, this type of service, this type of function, we can just engage in freewheeling policy and decide that they should nonetheless be immunized. I just want to, is that what you're asking us to do?
Not at all, Your Honor, and I'm sorry if I gave that impression. What I am saying is that the court should look to if they're fulfilling a duty that is required of them by the government. So if the person is, for example, a janitor, that isn't necessarily something that we have to hire the special person for, that has the special skills. That wouldn't necessarily entitle that person, the janitor, to qualified immunity if they were to, say, assault a prisoner. But if we have to hire a doctor to come in and offer medical advice, or in this case, even consult with someone at the jail to give them medical guidance, we would want to make sure that they are protected because they are fulfilling a requirement of the state that they meet that constitutional requirement.
I'm not clear what policy objectives are gained in the doctor position. And so we have, court saying that precedents that do conclude that precedents do exist point in one direction. There's no special immunity for doctors working for the state. What would make, don't we hold doctors amongst other people to a high level of professionalism? So what public policy should allow us to offer qualified immunity to the doctor working under these circumstances, and protect them from these types of egregious misconduct?
It's an excellent question, Your Honor, and there are several reasons. As has been mentioned previously, we have 62% of jails and private medical facilities relying on these private contractors now to fill this responsibility. If we remove any qualified immunity from people such as Dr. Ridge in this case, it's going to deter many of these private medical contractors from providing that same service. And in the previous case where there
That
did
seems a somewhat circular argument that because we use private doctors in prisons, they must have the protections of the state.
Yes, and if the states were to say we're not going to use those private doctors anymore, of course, those private doctors would not receive any qualified immunity because they would no longer be doing that responsibility to the state.
Is there then no limit by which the state can grant qualified immunity by virtue of contracting?
There's absolutely a limit. The limit here would be that it's only in the performance of their duties. So, for example, Dr. Ridge, in this scenario, where he's offering advice to a nurse on site at the jail, should have immunity. But he gets off the phone with the nurse and he goes in for surgery and doesn't pay attention. He doesn't receive qualified immunity there. And that goes to...
Well, wait, no, but I don't think that's the question. Of course, he doesn't get qualified immunity when he's treating his private patients. He's not acting under color of state law then. Doesn't even, come up. His private patients are just going to sue him for malpractice. They don't have a basis for using 1983 to sue him for violating constitutional rights because someone has to be acting under color of state law. So, given that, Dr. Ridge can be sued for malpractice by his private patients, by his jail patients. Why does he need qualified immunity? You say that a medical practice might be deterred from seeking a contract with the government if they don't get qualified immunity. But what they already have to consider the backdrop of malpractice law. They expect their doctors to live up to a professional standard of care. They have to carry insurance. This contract requires them to carry insurance. What do they need the immunity for?
Well, the immunity is so that they're not taking on an additional liability exposure on top of malpractice that they would be familiar with and they would have been trained.
What is I don't understand. What is the additional liability?
So an additional exposure.
What is, why would the fact that the lawsuit might be brought under 42 U.S.C. Section 1983 instead of the common law of tort in state court, why would that prospect be such a huge deterrent to seeking a for-profit contract to provide medical services to people in a pretrial detention facility?
For the same reason that such a cause of action would deter people from engaging in bad conduct. It's something that doctors are not familiar with necessarily. And they would have to wonder if they are now exposing themselves with any action.
Wait, what aren't doctors familiar with?
Doctors wouldn't be as familiar with the Constitution as lawyers and their attorneys, judges would be. So now they have to also account for the separate area that they're liable under, as well as
I'm
medical
sorry, you're
malpractice.
confusing me. What relevance is it whether a doctor is familiar with the Constitution? Certainly, they're familiar with what is considered to be the professional standard of care, what's considered adequate medical care, substandard medical care, egregiously substandard medical care. Certainly, the concept of whether you're indifferent to your patient's needs. Those are things that doctors would understand and be able to, judge as doctors better than lawyers.
Absolutely. And that's why that would actually go to my second point, which is they're well familiar with those and they've been trained to work within those standards and understanding those standards. So they don't hesitate. They're able to take action based off of their training consistent with those. By adding section,
I'm still unclear why deterring medical professionals from violating constitutional rights under the color of state law is a bad thing. By creating a situation where there would be a deterrent to them engaging in these types of practices.
well, it's not a bad thing to deter them, but it is a bad thing if they're afraid that they're going to be dragged into court every time a prisoner is unhappy with the level of care, especially if everyone around them is receiving qualified immunity. In this case, there's been no debate that Nurse Ratchet is entitled to qualified immunity or that the police officer who arrested.
So I have two questions, but one is precisely on this point. Couldn't a doctor just say, we get rid of qualified immunity, we don't extend it to doctors, to third-party doctors. The doctor just says, look, I'm not going to take this contract unless you indemnify me to the government. Case closed, no problem, right? Then they don't have to worry about their malpractice premiums going up. The government has to assume and internalize some cost for the unconstitutional behavior of their contract employee and have to perhaps supervise them a bit more adequately. What's the problem with that?
Well, that certainly would be an excellent outcome. Unfortunately, that would be up to each state to decide. And unless we're going to require every state to purchase this insurance and protect everyone that they hire, it may not be something that states will adopt, which then leads to doctors deciding, well, if I'm not going to be indemnified, I'm simply not going to offer this service. And then we have the issue of the 60% of jails relying on these people to provide medical care.
That seems like something the market would work out, right? We're not going to contractually, we're not going to have a doctrine prohibiting people from signing indemnification contracts, and presumably they're common. So why wouldn't that just be something that the market would adapt to if we didn't extend qualified immunity?
Well, so when you refer to the market, you mean the market of available medical employees? I just want to make sure I'm answering the correct question.
Yeah, that's right.
I would expect it would have an effect from the market. That effect may not be the one that we prefer, though. Medical salaries in the private sector tend to be about twice as high as what we expect in the public sector. If what we do is deter these people because they're not being indemnified, they leave. The people that are willing to fill these positions, if there's medical professionals willing to fill them, are not the most competitive. They're people who perhaps can't find other employment. And then we have a lot more situations such as this, where a person does not receive the medical care necessary and the injuries are far worse.
But okay, continuing this identification matter, and the market and contract forces. So here actually the county required as part of the contract that Amherst Medical Group carry the insurance and indemnify the doctors. So if Dr. Ridge is already now insured and indemnified as required by the contract, why should he care who's doing the indemnification and who's paying for the insurance? It's not his personal malpractice insurance. Amherst Medical Group had to buy the insurance policy. So why would he be, again, it would seem that the fact that he's going to be indemnified, he's got insurance, whether it's a malpractice case or a Eighth Amendment deliberate indifference case. There was a negotiation of this contract. In this instance, the government told the private party, the private company, that they had to buy the indemnification insurance. As Judge O'Rourke is saying, well, market forces, some private medical groups may say to the government, you want our services, you provide the indemnification. Why isn't, this is just a perfect example of, the competitive market is going to take care of this problem, and people are going to bargain over who indemnifies. And so why do you need qualified immunity to do that when the market can do it?
That is the situation in this case, Your Honor. However, that's not the situation all over. And doctors and nurses are needed in every jail and prison, or at least have to have access to those facilities to protect the people within them. If we only look to the facts of this case, yes, he was protected by this insurance from having that burden. However, a doctor a state over who does not have that protection should still be able to go into the prison and help people.
But
And if
what
we do-
value then the plaintiff's rights under Section 1983 who was harmed? If you offer immunity, she cannot receive compensation and attorney's fees for violation of constitutional right. How is that value supposed to be offset by the inconvenience to the state and its inability to adequately compensate sufficient numbers of doctors?
It's an excellent question, Your Honor. And my concern isn't so much about the interest of the state, it's about the interest of the people within these facilities. They do still have medical malpractice claims they can bring. And you bring up good points with maybe they can't receive attorney's fees. However, the alternative is that they don't have adequate medical care. They're left to the designs of, I'm sorry, Your Honor, I see my time is up. If you don't mind, I would like to finish my response and then just briefly surmise.
Yes,
Thank
of
you.
course, you may continue your response.
If these groups are deterred, they don't have people who are necessarily talented and qualified. They are left with who the jails can get to come in. They do still have access to medical malpractice in either situation, and they should. There should be a method of accountability. We just want to make sure that whatever method of accountability is not also making it harder for the prisoners to obtain medical care. Simply,
Is that the end of your answer? Because if so, I'm just like I did with Ms. Shepherd, I won't give you sum up time. Fair.
that was the end of my answer. Thank you, Your Honor.
Okay, thank you very much, Mr. Ramirez. Rebuttal. We have rebuttal from which petitioner's counsel will be delivering rebuttal.
Me, Your Honor.
Okay, go. You may proceed, Mr. Larman.
Your Honor, I would like to pick up with the point just made by respondent regarding the possible avenue of medical malpractice as an alternative to Section 1983. And I would just start by emphasizing the very clear differences between 1983 and a cause of action of medical malpractice sounding in state law. Section 1983 functions as a legislative vehicle to allow plaintiffs like Ms. Cameron, who have been egregiously wronged by government actors, to assert their rights, in this case under the 8th Amendment. And so I would just want to make very clear that it's petitioner's position that the medical malpractice possible claims that could have been brought in this case could not substitute for the remedy that Section 1983 provides to plaintiffs. But I would also like to respond to respondent's other argument regarding the idea that our qualified immunity doctrine must expand with the expansion of government services. And of course, petitioner contends and agrees that we ask more now of our government than we have ever. And we have recognized, as respondent pointed out, rights to medical care, rights to better medical care, and rights to practice religion for detainees and prisoners. However, the idea that our qualified immunity has to expand with that, it's essentially giving with one hand and taking with the other. We're saying to these prisoners and detainees, well, of course you have rights. Of course you have rights from the Constitution, but through the death knell that qualified immunity represents to those claims, what we are effectively saying is that you can't assert them. And so the idea that the qualified immunity must expand, it's a self-defeating argument. In that effect, when they are violated, when these rights that are established are violated, there's no redress, because effectively we keep on expanding the doctrine to cover these other actors. And I would like to point out, as Justice Abramowski pointed out, that essentially what this means under the position that respondent is urging, that what it would mean is that the government can contract out qualified immunity. So long as you are providing a government service, well, of course you're entitled to that immunity because you're doing it for the government. And as I see my time is out, but I will just finish my sentence, Your Honors.
Yes.
As government does more and continues to do more than it has ever done, certainly since 1871, when 1983 was enacted. We have to be cognizant of the consequence that petitioner's position would have on the legal landscape. Thank you.
Thank you. Thank you to all counsel for an excellent presentation, despite the occasional Zoom freezes and other glitches. I believe that us judges now have to go fill out our score sheets. And I assume, do we want to then come back into this meeting and give feedback? So Kanyo, how's that working? Should I guess everybody stays in the meeting, we can fill in our score sheets and then turn our
Yep, I'm
videos
gonna-
back on and give feedback?
Yeah, I'm gonna put the competitors in back into the waiting room so you
Oh,
guys
okay.
can deliberate, and then I'll bring them back in and you guys can
Okay.
give closing remarks to them.
Okay, okay, great. Thank you. Thank you. Okay. All right.
Okay, we're good.
Great. And Kenny, I just requested access to the Google Sheet from my Gmail. I couldn't quite figure out how to get to it through my buffalo.edu address.
Okay,
Sure.
I'm gonna make sure I can get it up. Okay.